So the mic should be on, and we just need to switch over the video.
Which number are you?
I don't know.
There's a number here, 3.
Good. Well, it is amazing to see so many people here, as Arlene said, at such short notice. Out of curiosity, can I ask how many people are from Switzerland? And how many people from elsewhere? Wow, that's great. Well, thank you for coming all this way. Well, in return for coming all this way, I'm afraid I'm going to deliver for you more knowledge about privacy, data protection, and American surveillance law than you probably ever wanted to know. And I'm afraid I'm not making very many compromises. This is the talk that I give to expert audiences, and so the other thing that I know is there's far too much information on my slides. So if you start to get a headache from looking at the screen, don't worry. I'll be covering, I hope, most of what is important in what I say. So I need to give some background to, I think, my own situation, how I became involved in this. I used to be, for 9 years, Microsoft's chief privacy advisor in 40 countries, actually, not the US. And round about 2009, the whole industry almost turned on a dime to start to evangelize something called cloud computing. And cloud computing isn't necessarily what you read about in the press, where it's just a place to store your emails and store your photos like a remote disk drive. The real significance of cloud computing is that it's massively parallel calculation, computation, sold as a commodity, over a distance, over the internet. And this is a sort of new mode of computation. It's something you can't really do any other way, because it allows you to scale your computing power instantly from one server to perhaps thousands of servers in enormous data centers. And the strategic significance for the entire IT industry is massive, because all of the calculations that might be done by your bank, by your government, by any other type of organization that formerly would have been done inside that building, on those premises, might now be done remotely in a data center in another part of the world. So in Microsoft, my job around 2009 became to figure out the strategy of how to persuade governments that cloud computing was safe and secure. And so I did my homework, and I started studying particularly the American law, the American legislation. And I realized about 2010 there was what seemed to me a very serious problem, which is what I'm going to be talking about today. I left Microsoft about 2 years ago for reasons connected with this, but I'm not talking about that today. And since then, I've been making speeches trying to make people aware of the problem. And really, I wasn't getting anywhere. I'd approached many of the European authorities about my concerns. They shrugged, said, well, it's a nice presentation, Caspar, but it's all theoretical. And then, of course, we had Edward Snowden. And I've been very busy since then. So to begin, I didn't know about PRISM when I was at Microsoft. I want to make that clear. I don't trust Microsoft now. And in fact, I'm a 100% free software person now. And as I've mentioned, cloud computing is really what the focus of this talk is about. On the left, you have a modern data center with thousands of ranks of computer servers. And on the right, you have, in fact, it's a photograph of the inside of AT&T switching center in San Francisco. And there's a doorway there marked 641A. Does anyone know what 641A means, the story of it? Okay. Well, way back in the 2000s, in about 2002, an AT&T technician called Mark Klein was working in his switching center, and some men from the National Security arrived with very impressive-looking badges, and they said, we want to construct a new facility inside your switching center. Please help us build it. And he built this room, and inside it was a new piece of equipment called a Narus 6400, which was a deep packet inspection box. It was designed to take in one of the fiber optic cables from the main western seaboard of the United States and split and copy all of the traffic. The box was designed to scan that traffic for certain patterns and keywords, and then some part of that information was being forwarded to the National Security Agency. And he thought this was wrong, because he understood enough about American law to understand that this impacted not just international traffic, but was also scanning the traffic of inside the domestic United States. So what he did is he went to the New York Times, and the New York Times, in fact, didn't write the story for a year until after the presidential elections of 2004. And then finally, I think in December 2005, it broke the story, and it became a big scandal in the domestic American press. And the controversy raged for about 2 years. And then in 2007, to try and put this sort of scandal to rest, the Americans passed an interim piece of legislation called the Protect America Act. And for the telecommunications companies that had probably cooperated in these and similar programs, the Protect America Act offered total retroactive immunity for all of their past activities. And this was very important to those companies because under the American law protecting the privacy of their subscribers, they could have been liable potentially for billions of dollars, which could potentially have ruined them, for, as it were, cooperating with the US government without the necessary legal warrants. And this law started to cement a new paradigm of trying to collect all of the data all the time and then minimize the impact on American citizens. But, as you'll hear later in the day from other speakers, in fact, this activity had been going on for some time already. It also meant, in respect of the new law, that as far as this international traffic goes, there were no more particular warrants for Americans. Previously to that, American law had made very strong guarantees for the rights of Americans, and instead, the court which oversees this area of surveillance in America, the Foreign Intelligence Surveillance Court, now approves so-called procedures. The procedures are how targets are selected and how the impact on Americans is minimized. But it was really a transition from the idea that a warrant means something about a particular target for particular justifications to saying that there's an authorization to do broad scanning of traffic. So to understand the hinterland of this, we have to go back to, in fact, 1978 and the era after the fall of Richard Nixon and Watergate, when there was a committee of inquiry set up by Senator Frank Church, which probed the activities of particularly the CIA and the National Security Agency in spying on Americans on the instructions of President Nixon, illegally. And what came out of that was the first Foreign Intelligence Surveillance Act of 1978. And this solidified the idea that there would be special protections codified in this American law dealing with foreign intelligence collection for Americans by nationality. And it also created this definition of foreign intelligence information, which is what this talk is all about. Now, the definition of foreign intelligence information contains the things that you might expect about money laundering and serious crime and terrorism and weapons of mass destruction. But even all the way back in 1978, it contained this section, which I've highlighted. And to get this text, you have to unwind 2 levels of definition. And this only represents, therefore, about 1/10 of what the whole definition is. But to me, this is very interesting. If you unwind the definition, it turns this part into information with respect to a foreign-based political organization or foreign territory that relates to the conduct of the foreign affairs of the United States. So if you think about that, that's just about anything. If you're a campaigner interested in global warming, if you don't like the Iraq War, if there's any aspect of US foreign policy in your own country using ordinary, lawful, democratic activities, this is covered. The other extraordinary thing about this part of the definition is, whereas it's admirable in American law that it is much more transparent to litigation, well, relative to some European countries, it is true. And so you can have very, very detailed argumentation, to some extent, about what these sorts of things mean. But since 1978, there is absolutely nothing. There's no law article, there's no executive guidance, there's really nothing in the congressional record about what this means. 40 years, nothing at all. So when I realized this in about 2010, I'd actually had it in the back of my mind, I think, from maybe 10 years earlier, but hadn't really done anything with it. And I put this together with what I was being asked to think about in terms of cloud computing. I realized there might be a little bit of a problem. In 2008, the Interim Act, the 2007 Protect America Act, was replaced, made permanent, by this law, FISA Amendment Act. And American legislation is rather confusing. It has two numbers. Now this is referred into the press as Section 702. In its original form, it was called 1881A. It deals with foreign intelligence information. It intentionally is supposed to be used only to target, I say only, that's 95% of the world, only non-US persons outside the US. And a US person is essentially somebody who is legally present in the United States. So a citizen, a green card holder, or a legal visitor. It gives a blanket authorization for 1 year. It requires the minimization of the access to the data on US persons after all of this has been collected. And it requires the telecommunications provider to provide all facilities or information to accomplish this in secrecy. If the provider doesn't comply, he's in contempt of the FISC court. It cemented the total immunity from civil lawsuits. And all of this must be done in a manner consistent with the US Fourth Amendment, which we'll come back to. Are you all with me so far? Okay. So the interesting thing about this law is it brought together three elements which had been there in separate pieces of legislation, but it brought them together in one place for the first time. Firstly, this idea of targeting the rest of the world. Secondly, it introduced this term remote computing services. Now, this is actually defined in a 1986 piece of legislation to do with criminal law enforcement. And the definition there was formulated back in 1986, but it's a pretty good definition of cloud computing. I won't go into the technicalities of cloud computing, but that covers everything today that we would call cloud computing. The strange thing is, nobody noticed the addition of that. Nobody remarked on it. Not the Congressional Research Service, not any law scholars, not any industry lobbying, nobody. It just went through. And this meant that the scope of this law had been dramatically expanded, because whereas all previous sorts of these laws had really dealt with interception of communications carried by telecommunications companies and internet service providers, this now meant that any data which was sent to America for processing in cloud computing data centers also fell under the scope of this law. And that'll be pretty significant, as we'll see. And thirdly, it carried over the full breadth of the definition of foreign intelligence information, so not dealing really with anything to do with criminality, or indeed a sort of narrow concept of national security, the vital interests of the state. It had this aspect of purely political surveillance, spying on other countries' ordinary, lawful, democratic activities. So one could say that, at least in this aspect, this law was designed for mass surveillance of any cloud data relating to US foreign policy. And it contained what I call this double discrimination by nationality. Because if you remember this definition, the writing is too small. But if you were a United States citizen, where that says relates, that would say necessary. So, if you're a United States citizen or person, necessary, a very high legal standard, but if you're not a United States citizen, relates, about the weakest legal standard. So the double discrimination comes both from that very definition of foreign intelligence information and from the targeting of this law to the rest of the world. So we now have to talk a bit about the Fourth Amendment. This really goes back to the time of the American War of Independence in 1776. And leading up to this war, the British, trying to sort of put down the seeds of revolution, used an instrument called writs of assistance, or sometimes called a general warrant, that authorized the king's soldiers to really break down any door, search any house, whenever they felt like it. And this, understandably, created enormous resentment amongst the sort of proto-revolutionaries. And after the War of Independence, when they were formulating their constitution, they passed this amendment in the Bill of Rights to guarantee that that sort of thing could never happen to them again. And it says, the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue, but upon probable cause, supported by an oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. So it might surprise you, but for 200 years or so, there wasn't really a case, perhaps because electronic communications hadn't been invented, there wasn't really a case which sorted out who this applied to. Was it people in the United States? Was it everybody? Was it people, as it were, legally in the United States, or people outside? I mean, it was a mess. The first sort of definite indications we had come from a 1990 Supreme Court case with an unpronounceable name that I won't attempt. That's a little bit relevant. It's not precisely the case we're looking for. But to jump forward to 2008, the review court, the appeal court of the secret Foreign Intelligence Surveillance Court, issued a judgment in secret. It was transiently published in 2010 and then strangely disappeared from the official website after a few weeks, but it so happens I downloaded a copy, and so had a transparency website, the Federation of American Scientists. And although the judgment, as is often the case, was redacted, that is, huge sections were blacked out, in one of the non-blacked out sections, sort of following a detective story here, was the idea that the Fourth Amendment did not apply to foreign powers, reasonably believed to be located outside the US. And foreign powers is a special term in the legislation which has a definition which unwinds to a foreign political organization, which I referred to earlier. And in 2010, the ACLU, American Civil Liberties Union, managed to do a Freedom of Information Act request, which brought to light a sort of FBI training manual on the use of this FISA 702 law, which again, in the non-blacked out sections, showed that something interesting had happened to the meaning of this probable cause criterion. And then in 2012, just last year, summer last year, there was a hearing in the US Congress about the renewal of this FISA 702 law. And civil liberties representatives in the US were giving evidence about whether it's constitutional and the impact of this law. So there's a little video clip I've got of that hearing, and what you're going to see is, sorry about that, what you're going to see is a clip where a Texas congressman is almost interrogating the guy from the ACLU, Jamil Jaffer, about what his problem is with this law. And it was, in a sense, when the penny dropped for me, that there was really no doubt that this Fourth Amendment gave no protection to anybody else in the world, which I guess now everyone knows and doesn't seem so surprising, but it was really only this time last year that this crystallized.
Does the Fourth Amendment apply to foreign targets and foreign lands? I don't think that's the question. No, that's my question. So I promise you it's the right question, because that's my question. Does it apply? I don't think it does. When you say you don't think it does, well, I mean, the circumstance of this statute, I don't think it does. Right? We certainly haven't made the argument that it does. Does the Fourth Amendment, I'm not talking about statute, I'm talking about does the Fourth Amendment apply to foreign nationals in foreign land? It does not. Does the Second Amendment apply? I don't know the verse on it. I think A That's my second point.
So in case nobody got the point there, I mean, the US Congress is making fun of the idea that the rest of the world deserves some privacy protection. I particularly like that clip because he's having a lot of fun at Jamil Jaffer's expense, and now we can have a little bit of fun at his expense in ways he didn't anticipate. So back last year, the European Parliament was, as it often does, issued a commission to write a report on the impact of cloud computing and cybercrime. And I guess the original brief for the report was to kind of continue the drumbeat mantra of cybersecurity, 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 more surveillance, cybercrime, terrible. But I happen to know the professor who was being given in charge of the group writing this report, and he called me up and said, Caspar, do you want to help us write this? And I managed to persuade them of what I discovered about the cloud computing surveillance situation and say, it's really important you focus a lot of your report on this. And to give them great credit, they did, because I don't have an academic reputation, and they had a real sort of leap of faith in me in investing so much in the analysis which went into this report. And it kind of turned the subject matter of the report around to squarely focus on this problem of once you put your data into cloud computing, what actual protections do you have against this sort of surveillance law? So, as often happens with these reports, when it was published in November, it sat on the Parliament website, absolutely nothing. No media interest or awareness whatsoever. The Parliament didn't seem to have any press office that could publicize this. And as you do, if you're a surveillance policy wonk, I was spending between Christmas and New Year last year watching the coverage from C-SPAN of the US Congress debating the renewal of the FISA 702 law. It had run up for its 5-year term for renewal. Of course, when you're going to renew that sort of law between Christmas and New Year, when no one's paying attention politically. And it just sort of got my goat. So I called up a lot of the journalists I knew when I was running a think tank. And then a brilliant journalist called Ryan Gallagher, who writes for Slate magazine, wrote a very tight and accurate 800 words describing the gist of this part of the report. And then there was a little flurry of media attention. And there were 1,500 tweets in a week, a few follow-up stories in the German press and the French press, and finally, after much trying, the UK press. But the general reaction, as you can understand from around Europe, is what on earth is happening? How can this be possible? What is the point of all of our data protection authorities, all of the people who are trying to assure us that data protection law, the respect for fundamental rights in Europe, means that this sort of thing clearly should be impossible? The reaction on US blogs was much less, but typically along the lines of, oh, so the rest of the world's kind of upset about this. They didn't realize? Well, who's going to stop us? Well, how did this come about? How is it that cloud computing has been such a big policy topic for the previous 3 years in particularly Europe? And all of the institutions of the European Union seem to have been mesmerized by what I call cloud wash. There were a huge number of reports written, some paid for out of European Union taxpayers' money, which were frankly dreck and dross. I've put up some of them here. They all skirted around this problem. They either didn't mention FISA at all, or they concentrated on the wrong parts, or they didn't analyze it. And some surprising people are involved in this. For example, the European Data Protection Supervisor, Peter Hustings, possibly the most distinguished data protection regulator that we have, gave a speech in April 2010 at the conference of the Business Software Alliance. The Business Software Alliance, bluntly, are the main American lobbyists who have been trying to do down the European privacy regulation for 10 or 15 years. And Peter Hustings seemed to buy into this idea that there was no problem with cloud computing. In fact, he wanted to make it easier for European data to pass into cloud computing. I won't dwell on the other sort of unfortunate materials we've got here, but the general structure of the argument is always the same. The argument is that under the Fourth Amendment, Americans have good protection for their privacy under US law, and if you compare that with the patchwork around different European countries for the equivalent protections under European law, Europeans, arguably in many cases, don't have such good protection as the Fourth Amendment in their own countries. And therefore, don't worry, be happy about the cloud. But you can see the fallacy, because when your data moves to an American cloud, you have no protection whatsoever. An example of the kind of misdirection and omission that was present from US lobbying is, in fact, in the US ambassador to the EU at the time, he's just moved on, where in a section of his speech from last year, he talks about, or tries to refute, some of the so-called myths about the Patriot Act in particular, which this talk isn't mainly concerned with. And he says that the provisions in criminal law enforcement doesn't discriminate between US nationals and Europeans, but he didn't talk about FISA. And they haven't so far. So now we have to think about, well, what were European data protection authorities doing through all of this? One curiosity is when you look back through sort of 10 or 12 years of European data protection authorities' opinions. These are like quasi-legal judgments which they give to analyze a particular subject in privacy and data protection thoroughly, normally about 20 pages long. There have been like 150 of these issued now since 9/11. And they always refer to the situation of requests from law enforcement, implying that there's going to be some kind of due process, some kind of warrant, some kind of particular instrument whereby an American authority will request data from a European entity. Well, the diagram here is actually produced from 2006 by the American Civil Liberties Union, and it was designed to illustrate what was going on in the larger scale with what happened in Mark Klein's 641A room in San Francisco. And it shows they managed to extrapolate from the documentation that he brought about the splitter, which is diagrammed in the bottom left, to figure out that it wasn't probably just happening only in San Francisco, it was happening in the other major internet exchange points also around the US, and feeding all of that data in like the tentacles of an octopus into Fort Meade, NSA's headquarters. That's not a request. That's a state of continuous scanning mass surveillance. There is no due process. All of this data was being hoovered up continually from this time, and as we'll hear later in the day, even earlier. So this is a slide I had for a talk, in fact, just before Edward Snowden, and that was entitled, "Is Cloud Valence a Real Risk?" Yes, it is a real risk since the 7th of June. We know now. And I guess for those of you who have some technical background in the audience, there is a fundamental point to be made here about encryption. When you are talking to some other web service over the internet from your computer, you see that little padlock symbol in your browser. And that means that your data should be strongly encrypted from your computer till it goes inside the front door of the data center someplace in San Antonio, Texas, or Amsterdam, or Singapore, or some other continent. But once that data gets inside the data center, it has to be decrypted, because it's impossible to do useful work on data whilst it's encrypted. It's just scrambled nonsense. So once it's inside the data center, it's all available as plain text to be got at. And my belief is the future of cloud computing. I mean, cloud computing can't be sort of disinvented because it's just too useful to be able to have this mass parallel processing power on tap, which can scale instantaneously according to demand. So there's going to be a demand for it. But if governments want to be able to wiretap the cloud systematically, then it's going to be very inefficient for them to do it the way it was done in San Francisco Switching Center, with a hardware box, because this elastic property of cloud computing means that if the demand for cloud computing in any particular application can scale instantly from one server to maybe tens of thousands of servers, well, they'd need 1,000 of those DPI boxes on standby, just sort of sitting around in the data center in case that peak demand was hit. So the implication is, if governments want to get into the cloud tapping business, they're going to need to coerce Amazon and Google and Microsoft to do it for them on the inside, in software, So every subroutine, which was actually doing useful work, would have like a shadow subroutine underneath, which would be doing the scanning and the targeting in software. And as I've mentioned before, the sort of economic incentives and drivers to do this, just on cost grounds, are so enormous that every business, every organization is going to be confronted with the pressure to do this. And unlike echelon surveillance, which you'll also hear about later from the sort of previous era of surveillance, which was really only about interception of communications, communications you can protect between the endpoints using encryption. But with cloud computing, it's irrelevant, at least against state surveillance like this, because once it's arrived in the data center, secret national security laws like FISA can just suck that data from the inside in bulk where it's unencrypted. So from a European point of view, all of our data is now at risk. Echelon was like a tiny slice of data which we sent outside Europe in communication channels. With cloud computing, if companies like Microsoft and Google and Amazon win these contracts to process all of the data from all European businesses and governments, well, all of that data potentially in Europe becomes at risk. So we have got to talk a little bit now about the structure of data protection law. For 40 years, data protection lawyers have tried to figure out legal structures for how to make it possible and legally safe to take data out of one country and one legal regime and to export it for processing, originally for things like credit card transactions and airline reservation systems in the 1970s, and process that, or at least make it available, over telecommunication networks in another part of the world. And the basic model that's evolved is that there should be a contract. There should be a legal contract between the data exporter, say in the EU, and the organization that is going to take that data, say in the US. They have to conclude a contract. And the European Union has tried to provide rights, guarantees for the rights of individuals, by obliging companies to put in special clauses in these contracts to say, if push comes to shove, the individual has rights against the parties to this contract, even though they themselves, as individuals, are not parties to this contract. So it's quite an unusual legal idea. But when you try and apply this model to the mass transfer of data in cloud computing, you can see there's a bit of a problem, because the model that the EU has now sort of gravitated towards, and which is now really baked in to the draft new data protection regulation, which is right now being hammered out in Brussels, is Microsoft or Google would get a sort of security accreditation from a private sector auditor for their entire cloud platform, something like Google Apps or Amazon Web Services or Microsoft Azure. Once that's been issued by the security auditor, all of the other data protection authorities across Europe must accept that. Then data can be transferred into the cloud. And then suddenly, somehow, all of these questions of mass surveillance have disappeared into a puff of audit. And the club of, or committee of European data protection authorities, which has the very obscure title of the Article 29 Working Party, but that just means no more than the Committee of European Data Protection Authorities, 29 of them or so. They actually wrote one of their opinions about this new mechanism, which again has the zingy title, Binding Corporate Rules for Processors. Just trips off the tongue, yeah? They wrote an opinion about how this new mechanism was supposed to work, and they said that this audit coverage, for instance, might include decisions taken as regards mandatory requirement under national laws that conflict. Well, we do have a conflict of law. We have a massive conflict of law. We have the US government asserting their right to untrammeled access to any data that falls within their territory, and we have European data protection law saying that this shall not happen except with a sort of due process and special instruments that have been set up to authorize case-by-case access by law enforcement authorities, not some kind of carte blanche for political spying, which is actually in the American law. So here's a sort of newsflash for data protection authorities. Lawful access by national security authorities and intelligence agencies is not part of the threat model of a private sector security auditor. A private sector security auditor is trying to look out and secure that cloud against external hackers and possibly against corrupt or criminal insiders working in that company. But they're not there to put a stop or to prevent or to detect activities by that country's national security agencies. So this seems to be a fundamental conceptual loophole in their mental model of what's going on. But even if you take at face value what they said about how this is supposed to work, it turns out that the data protection authorities who drafted the small print had already put in loopholes, because they said that if, for example, Microsoft were to get one of these 702 orders under FISA, requiring them to open up, as it were, their data centers from the inside and allow the data to flow out in bulk to the National Security Agency, well, they say that such a request should be communicated back to the European entity, unless it's prohibited. Well, guess what? It is. Of course it is. So they provide, as it were, a loophole saying that they don't have to tell the European authorities after all. So this is a sort of matrix which is trying to illustrate some of the complexity here. And on the left-hand side, we've got essentially three categories of information we should be thinking about. There's stuff for criminal law enforcement, which includes terrorism. Then there's stuff for what you might call bona fide national security issues, the vital interests of the state, where there's kind of a mutual recognition between states, but it's still very murky. And then there's this third area, which is basically just political spying in arbitrary interests of that country's foreign policy. And then the two columns are, if we consider the situation, as it were, from one European country, including Switzerland as the EEA, from one European country to another, versus what happens if European data is sent to the US. So one can argue about it, but essentially the green zones are pretty safely covered by legal arrangements already. The yellow and grey areas not so much, but the red areas are completely unprotected. They're not protected by the Fourth Amendment, as we've seen, not protected by European data protection because of the loopholes. They're not protected by something called Convention 108 by the Council of Europe. It's a sort of bigger group of countries. They're certainly not protected by the Council of Europe Cybercrime Convention. Civil society was very upset about that in 2001 because it didn't build in explicit human rights protection, which would have made this sort of thing illegal. And it's not protected by the European Convention of Human Rights because the US doesn't recognize the European Convention of Human Rights or any other equivalent relevant instrument. So then, of course, we had Edward Snowden. And the main programs that he revealed, there's a lot here that I haven't included, but just to touch the surface, which other people will be going into later in the day. We have PRISM, but the material on the PRISM slides only really shows consumer-facing services, things like webmail and Skype and PayPal. The business cloud computing, the sort of Amazon Web Services, Microsoft Azure, which organizations want to use because it's cheaper, to process your data once they've got their hands on it, that isn't so far showing up in any of the slides. But it's my view that the powers in 702 are equally applicable to that big fat target of business cloud computing. So a big question is, are there other programs which do aim for that business cloud data, or is that something the NSA hadn't got around to and was maybe just about to get around to? Then there's a reference to upstream, which is grabbing data from fiber optic cables, probably mainly as telecommunications land those cables, on the beach. It's probably there, not necessarily under the sea, where splitters, like the one Mark Klein found, are being used to split that signal and divert it to the NSA. And then internet exchange points, where different companies, big companies operating internet communications, exchange their packets of data. Then there is X-keyscore, which essentially is a massive federated, distributed index of data gathered from these methods and also other methods of collection from all around the world. X-keyscore indexes it all. It indexes IP addresses, ports, cookies, internet handles, buddy lists, identifiers, email addresses, obviously. And particularly interestingly was cookies, because people think still that somehow you can separate issues of commercial privacy from all of this stuff about fundamental rights and mass surveillance. Well, guess what? The cookie which Facebook drops in your browser might be used to target you for political surveillance. There really is no distinction, if there ever was anymore, between commercial privacy and these questions of fundamental rights. We also learned that there is now this rolling buffer where it sounds incredible, but in the past few years, the capability has been developed to copy the entire flow of data, at least on international links on the internet, for something like 3 days. And the metadata, the who's talking to who information, for a longer period, probably something like 30 days. And this is on 150 global sites and 700 database servers, and this was in 2008. We don't know what's happening today. So that's just a completely mind-blowing transformation of the paradigm of mass surveillance. It gives the authorities a time machine, somebody about whom there was no prior suspicion. Now they can go back in time and find out what anyone on the internet was searching, who they were talking to, and indeed what the content of that communication was. And then we have Bull Run, which is the code name for an aggressive, multi-pronged effort to break into widely used encryption technologies. And I've just got an idea that Bruce Schneier might want to say a word or two about that, so I won't say any more for now. So on the 7th of June, the same day that PRISM was revealed, Admiral James Clapper, the Director of National Intelligence, confirmed that the PRISM program was all about Section 702. And I must admit, when that happened about midnight, and I first saw the PRISM announcement, I thought, wow, it's all true. In fact, it was all true, and then some. And then by the end of the day, Admiral Clapper had essentially confirmed it was all based on the PRISM 702. So that was a big day for me. What I wasn't expecting when I was doing my analysis in abstraction, theoretically, was I knew that these so-called targeting and minimization procedures, which the FISC court now has to kind of rubber stamp, we knew they existed. I never expected to see them. And then on the 20th of June, The Guardian published them in their full form from 2009. And you can, they're very sort of turgid and bureaucratic, but when you work through them, there are zero protections for non-US persons. There was nothing that the US was doing, as it were, which they didn't have to do, some sort of voluntary adherence to respecting the privacy rights of non-Americans, nothing. The targeting procedures were solely concerned with establishing the foreignness of the target, so various rather legal, not necessarily useful criteria were applied to establish that the data was about non-US persons. And once you'd sort of tick that box of more than a 50% probability that it was about a foreign person, then any amount of exploitation of that data for spying purposes was allowed. And there was no restriction on the full breadth of foreign intelligence information, including the section which I highlighted. So what were European data protection authorities doing about this? The 29 member, or sorry, that's actually not connected, but what were the Committee of European Data Protection Authorities and the European Data Protection Supervisor? They've been silent, essentially, for their entire lifetimes about foreign intelligence. If you work through 150 opinions, or in fact the entire corpus of all the opinions they've ever written, they've never mentioned Patriot, except in one footnote in 2001. They've never mentioned Pfizer. They've never mentioned Protect America. They've never mentioned FAA. They've never even mentioned the term foreign intelligence. It's as if that whole realm of activity does not exist for data protection authorities. And all of the, if you like, loopholes which I've referred to, in fact, boil down to 4 or 5 words. What does a legally binding request from the US mean? And what does national security mean? Does that mean the national security of America? Or does that mean the national security of European states? Now, you might think the answer to that question is obvious. But I'll come back to that later. But if we look at the debate that's now raging in the US about everything that's been revealed, it's not actually PRISM and Section 702 that's controversial. What is controversial is something I haven't really talked about, which is the Section 215 of the Patriot Act. I think other people will get to that later in the day, which is about the collection of metadata, who is calling who, and location data as well, from mainly telephony, but also emails. And that applies to domestic communications in the US, domestic telephone calls, and international as well. So I won't go down an explanation of that, but other extraordinary things have happened. For example, former National Security Agency Director Michael Hayden, who was in office at the time of 9/11 and essentially when these systems were beginning to be built up. He's been going around saying, well, the Fourth Amendment is not an international treaty. I mean, who should be surprised about this? He also talks about the home field advantage, which he means essentially any data sent to or routed via the US or stored there in cloud computing is essentially regarded as fair game. But until 2012, and in fact for many years previously, I would be on the conference circuit of international privacy conferences, and you'd have representatives from the US State Department, and they'd be making these speeches of soaring oratory praising the virtues of the Fourth Amendment and how wonderful it was. And since this was directed to an international audience, you would think that they were implying that this gave some protection to everybody else. Well, it doesn't. But they were implying that it did right up until last year. So I'm going to skip over the stuff about the Patriot Act. I think other people will talk about that. And I want to think a bit about what needs to be done. The data protection regulation going through at the moment has this loophole built in. If this data protection regulation goes through, as Vivian Reding, Commissioner Reding, wants it to do, as most people want it to do, I don't think people have realized that we will not be okay if the regulation goes through in its current form. If the regulation goes through in its current form, these loopholes exist, and the situation may not in fact get better, it may get worse, because the discretion of individual data protection authorities to object and to stop this, if they wanted to, will be less. They will have less discretion individually. Essentially, there will be this blanket accreditation in respect of these systems, which data protection authorities cannot object to. It's very odd, but the parts of the European Commission, agencies like ENISA, the Trust and Security Unit inside DG Connect, which does this sort of thing, they have sort of like reversed themselves and flip-flopped in the past 2 months. First of all saying, oh no, our job isn't to protect against American spying or the National Security Agency. That's outside the scope of our responsibility, because in the Treaty of the European Union, national security is exempt. Well, now they've sort of realized that that position is politically untenable. So they've issued some rather weaselly worded memos saying, oh yes, perhaps it is in our responsibility after all. Yeah, we can do something about this. But essentially for 15 years, they said it was not our department. Then in the new regulation, there is something called the lost Article 42. Just before the new data protection regulation was published in its final form, I think in January last year, a draft leaked a couple of months before, and in this draft there was a so-called anti-FISA clause, and that anti-FISA clause said unambiguously that if, say, Microsoft or Amazon and Google acceded to a request to, say, one of these 702 orders, they would be breaking European law, and they must get permission first by telling and getting approval from the relevant European Data Protection Authority. Which sounds nice, but in fact they dropped it in the final regulation. They dropped it, as we now know, from very heavy American lobbying. And we can say a bit more about it during the day in question and answers, but essentially this Article 42 is not a credible deterrent because, as Marissa Mayer, CEO of Yahoo, said a month ago, if I don't comply with this Section 702 order, or if I talk about it, if I tell a foreign government or a foreign data protection authority, I am breaking the US Espionage Act. I could go to jail for 10 years and possibly 30 years. Whereas if they don't comply with Article 42 and fail to tell European data protection authorities, well, they might get a fine of, a few $1 million, $10 million tops, years in the future. More than just a decimal point in the balance sheet. So there's a certain imbalance of deterrence there. What can we do? Well, I now had a chance to write this report, which came out about 4 or 5 days ago. You can download it from, if you look for me on Twitter, it's like all over there. And there I've basically tried to analyze what I've told you about so far, and I propose some recommendations. The recommendations are essentially aimed at building up both a domestic European autonomous cloud computing capacity based on free software, and at the same time giving warnings to individual citizens when they put their data in American clouds. I want a big fat pop-up warning box that says, do you realize if you click here, you're putting your data in range of political surveillance by a foreign government? Do you agree? And so, obviously, the purpose of that is to create a political effect. It's to raise awareness. So I want to create this kind of pincer movement. On the one hand, building up a European software cloud industry, and on the other hand, raising awareness. And I hope this will have the effect of American cloud companies losing a lot of money. And when and only when they've lost a lot of money, they will start lobbying the US government to recognize our privacy rights instead of lobbying in Brussels to abolish our privacy rights. At the moment, today, if you want information security, buy an exercise book and get a biro, because we don't know what to trust or how to make it secure. And again, I'm sure other speakers will touch on that. Where we need to get to, essentially, is to get America to recognize our human rights. And at the moment, when you put your data in an American cloud, it's like putting it in a privacy Guantanamo Bay. That's it. Thank you very much.
Thank you, Caspar. Thanks very much. Are there any questions?
Oh, yeah, questions.
I see a question up there. Does anyone have a microphone up there?
Now it's on. Hi, I'm Richard Hill. I'm one of the speakers later on. But I thought I'd bring out a couple of points. First, very trivial one. Switzerland is actually not in the EEA, but Switzerland is complicated. And I'm pleased you targeted Carl Bildt. He is also one of my targets. We didn't have time to throw things at him, but I saw his name up there. Thank you for that. The really substantive point is I think that in the exchange in Congress, the civil liberties chap gave up much too quickly on the Fourth Amendment. That's the privacy clause in the U.S. Constitution. What I would have said in his place is that that does apply outside the United States because it's the implementation in U.S. law of Article 12 of the Universal Declaration of Human Rights, which is a privacy protection clause. And that is a universal declaration to which all states are bound, even those that are not members of the UN. But of course, the US is a member of the UN, so that's explicitly a treaty that the US has agreed to. So yes, the Constitution is not a treaty, but Universal Declaration is, and the Fourth Amendment is just the US implementation in domestic law of that legal obligation. So I think we should go back and hammer the international law aspects more. That's one of the things I'm going to talk about.
Yes, well, I mean, thanks for making that point. I think the other speakers will be far better able to address those questions. But what I would make the point is that unfortunately, no US civil liberties organizations are so far running a case to establish those rights, the rights of a non-US person in respect of all of this. All of the cases are about the rights of Americans, and all the political discussion is still all about the rights of Americans in the US. But yes, there is that essential Everest to climb through those sorts of ideas, trying to establish the rights of non-US persons. And yes, there is a sort of chink of light in theory, but it's a very, very long way to go. And there's no cases, as it were, even starting to make that case.
There's a question.
Should I just say it like that? Yes, I would be interested to know a little bit in more detail how far this definition of foreign affairs and foreign political or political activities goes, and in particular, that obviously straightforward definitions, if someone is doing political activities in a foreign country or a foreign government falls under this definition. But how far, for example, does it go to cover commercial activities of EU companies? And yes, I'd like to have your view on how far this could be interpreted, and also if there are reasons to believe that it has been used, for example, for commercial intelligence.
It's a very good question. I guess I'd make 2 points about that. One is that in the past 3 months, I think Obama, maybe somebody else, has given an assurance that the Defense Department does not engage in economic espionage. But if you parse that statement carefully, that would not include the activities of the CIA. The second point I'd make is in some of the cloud wash papers, some of them which are so intellectually offensive and disingenuous, I can't really bring myself to cite them. There's one in particular from a law firm from Hogan Lovells, which has essentially been acting as a US lobbyist by proxy. Not entirely clear if it's for the US government or just for the private sector. They issued 2 papers, one last year, which didn't mention FISA 1881A at all, and then they came back in June this year with a sort of, oh, we forgot FISA, yeah, this is our analysis of FISA. And it looks like a law paper, it looks like scholarship. But when you start to go through it, you find essentially glaring, howler, elementary errors of scholarship, and frankly, which cannot be an accident. And there's one footnote which bears particularly on this question. They refer to a debate in the original FISA debate in Congress in 1978, where that is the only place that that definition, that political definition, is discussed. And they say in the footnote, well, people like, they don't mention me by name, but people like Mr. Bowden, who refer to this, are really quite unnecessarily worried, because in this part of the debate, they say that, for example, if you're worried about academics or political campaigners doing ordinary lawful democratic things, no, 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 that's not the intention of this law. But what the law firm Hogan Lovells did, which is inexcusable in scholarship, is they truncated the quotation. Because immediately after that, they say, for Americans. So that, firstly, we only have that scant reassurance in 40 years of this policy history. And then the thing they pointed to only applies to Americans. And that's all we know. We know nothing else. I think it might be worth saying that from what we know, Edward Snowden probably only had access to a fairly basic level of NSA networks. And so the CIA is building a $600 million new data center. We also know from some material that's in the report, but I couldn't mention now, that essentially the CIA gets its own copy of data. Once this data is filtered for this 50% foreignness criterion, then its data stream can be copied, the CIA gets its own copy, and then it will be analyzed under its own missions and authorities. So that's where I would look. And frankly, we don't know anything about that because there's nothing so far in the Snowden material about the CIA or from other sources. And so we need to pay attention to that.
Duncan.
Hi, I'm Duncan Campbell. I wrote the Echelon report for the European Parliament and I'm assisting them again. Caspar, my question is about your matrix of risk, the green, red and yellows. And the question will be, but I'll make some points, would you like to revise that to deal with the intra-EU and EEA threats that have now been disclosed? Quite specifically, Britain's wholesale participation in the tapping of the fibre networks, which carrying roughly 25% of the traffic through and into Europe, but much more significantly and subversively and not yet understood, the number of other EU countries which are playing a role in this out with what we now have to call the Five Eyes Agreement. And that is most particularly Sweden. Please take note, the person who just mentioned, Carl Bildt, they signed up to this in 2008. They're covering the Baltic. They're the most important participant in this 3-day buffer system outside GCHQ and NSA. Denmark is also involved in this, Germany to a lesser extent, France off and on, Italy, Sweden all have, Italy and Spain all have participant roles. Cyprus is the host to a massive facility and then affecting the EU on the boundaries. So the internal EU threat, how would you like to deal with that if you accept it? Thank you.
It's a very good point. Thank you, Duncan. The first thing I should say is that when I was commissioned to do this report, the scope of the commission was strictly the NSA and the US. But my colleagues with whom I worked on the report last year on cloud computing, they got the commission to analyze GCHQ and the French system, and I think the Swedish system, and the German system, and a couple of others. So that report should be coming out, I believe, in the next month. And because what I was trying to do in this report was essentially weave together 50 years of policy history with the revelations of 3 months, I could really only cope with analyzing the stuff about the NSA. But you're absolutely right to now turn the attention, which I haven't talked about what's happening inside the EU. When I did that matrix, I was really concerned with the legal position. But it is absolutely true to say that it would, we think, would be totally illegal for what has now been exposed with GCHQ and Belgacom, for GCHQ to mount essentially a hacking attack on another EU country and ECHR country, in that way, completely illegal. And so we very much hope there will be several forms of legal action brought. But I guess the point I would make is that, assuming it is found to be illegal, in the EU, that sort of state-on-state spying is illegal. But the situation for the US to do that to one of our states, in US law, that's totally legal. It's not breaking any US law, absent the point about UN-level declarations, which it's a complicated story, but the US hasn't exactly implemented. So yes, that risk matrix was the sort of theoretical legal position, but of course we know, obviously we know now, that this sort of state-on-state spying does happen. And we'll have to figure out what to do about it. So that's the only answer I have at the moment, but we can talk about that more during the day.
Anyone else? Yes.
Thank you. I wonder why do your ideas of getting better to the future, why do you mention the can we rely on free software? I'm thinking of years of a bad Debian Linux random generator. I'm thinking of the story of Free Unix, where 10 years after the fact, some person who was paid by the FBI told them that he had implemented a backdoor. So, and Linux Torvalds resides in the US. So what can we do really?
So I'm not going to pretend that free software is any panacea. Of course, it has many, many, many bugs. The community is less controlled. But it's just a hunch. If I think about what I know from what I saw inside Microsoft, and that's not a story for today, basically, you've got an industry which is private security vendors producing proprietary solutions, and I don't really think I want to trust those as opposed to free software. At least with free software, of course, it's not true that many eyes makes all bugs shallow. Almost any vulnerability can be a security vulnerability. The whole thing's very precarious. But I just think if you've got to build from a base for somewhere, then free software is the way to go. But your point is taken. It's no panacea.
It's Bruce Schneider. I just make the point that it's probably the best way to bet. I mean, all we're doing is looking at what we know and assuming what we can and trying to make the best decisions. So, I mean, I would bet on free software before I would bet on Microsoft also, even though I don't know either way.
Just as a point, I would say, I'm one of the speakers later, and I would say the same thing about free software, which is that we may have the possibility of using free software and building on it, and actually studying how it goes wrong. And this is something which we really have a hard time doing, though it's not impossible with binaries from Microsoft. But we do, I think, also have some stuff in the future where we will know those things. And so if I were a betting man, I would also be betting on free software, just as a thought.
Thank you. We are still on schedule, and I intend to stay on schedule, so it is a coffee break now for half an hour.